Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
Now, there's been speculation today over the identity of the high-profile businessman who's taken out an injunction against the Daily Telegraph. The paper had wanted to report on how he's been accused of sexually harassing and racially abusing members of his staff, but has been prevented by the courts from doing so. It's led to questions about the use of non-disclosure agreements and the fairness of the legal system in this and other similar cases. Here's Fatima Manji.
Non-disclosure agreements, the legal contracts most famously used by media mogul Harvey Weinstein to keep women accusing him of sexual harassment quiet. The scandal around those allegations and the Me Too movement that followed led to scrutiny around how these NDAs are used. And now there are fresh questions. The latest high-profile case involves a senior executive and two companies of the same group. 5 employees of the companies made allegations relating to sexual harassment and racial abuse of staff. All of them entered into NDAs before their claims went into public record. The Telegraph discovered the existence of the allegations and contacted the employees, at least one of whom is happy for the information to be made public. But the Court of Appeal has issued an injunction saying that the Telegraph may have obtained the information in breach of confidentiality of the NDAs, and that there is a real prospect of harm to the senior executive and companies, which may have implications for their employees.
It's worth stating that the Telegraph never planned to name any of the victims in this. And equally, we have to weigh up here the commercial interests of a businessman who doesn't want his name to end up in the paper and the public interest at wide in naming someone who has been accused by multiple employees of wrongdoing.
The Prime Minister's already pledged the use of NDAs will be looked at. Today she was asked if she backed this court injunction.
I can't comment on a particular case that is currently before the courts. Non-disclosure agreements cannot stop people from whistleblowing, but it is clear some employers are using them unethically. And the government is going to bring forward measures for consideration, for consultation, to seek to improve the regulation around non-disclosure agreements and make it absolutely explicit to employees when a non-disclosure agreement does not apply or cannot be enforced.
The legal battle between the Telegraph and the unnamed businessman is still ongoing. But the gagging order could be broken by an MP inside the House of Commons using parliamentary privilege. 7 years ago, one MP broke an injunction preventing the reporting of footballer Ryan Giggs' extramarital affair. Whether or not the businessman's identity is revealed this time, questions are once again being asked about whether our courts have become playgrounds for the powerful.
Fatima Manji reporting. Well, earlier I spoke to Labour MP Jess Phillips and I began by asking her if she found herself in the unlikely position of agreeing with the Daily Telegraph.
Yeah, I agree with the headline. I agree with what seems like total consternation at the ability of certain people to act with complete impunity and as if they are untouchable, whether that's by the laws in this land, common decency, and in the case of the Daily Telegraph, the press.
Right, but there's one way around this, isn't there? And that is if someone like you, a member of Parliament, uses their parliamentary privilege to name the person in question.
Yep.
Do you know who they're talking about?
I don't know who they're talking about. I am hoping to speak to some of the people involved, and I wouldn't bat an eyelid for a moment about naming the person once I had spoken to those people and felt that it would help them. Because to me, whilst there is arguments about press freedoms in this, there are arguments about due process and whether you should name people. I understand all of those. But to me, this is about how our laws, the spirit of our law, is being completely roughshod over by people with money.
But you are going after this particular name, and when you know that name, you will reveal it in the House of Commons.
Absolutely, if that is what they wish for me to do. This is not for me to decide. This is for those people who have been wronged to decide.
Are there any circumstances under which you would allow non-disclosure agreements?
Of course. Of course, I'm not here to say that non-disclosure agreements in their entirety are wrong, because in lots of cases they enable people to end with a settlement that means that they don't have to go to court, which can be very traumatic, especially if you don't have an equality of arms against your employer. You're just a normal employee, and that it allows a line to be drawn. However, in the case of sexual harassment or anything where there is a criminal complaint that has been made, whether that's fraud, whether that's violence, whether that's sexual harassment or sexual abuse, where there is a criminal threshold, an NDA is not appropriate.
So the Telegraph agrees with you. The Prime Minister seems to agree with you. Surely the next thing on the cards is a change in law.
Well, that is what I would absolutely hope to see, is that if our laws are being able to be abused in this way, we need to change those laws to make sure that they are clear and that in this fight they protect David, not Goliath.
Jess Phillips, thank you very much indeed. Well, joining me now is Susan Mackay, QC, founder of Furore Law, which specialises in gender discrimination, harassment, equal pay and sexual abuse, and Gareth Brahams, founder and managing partner of a leading employment law specialist firm. Welcome to you both. Let me start with you, Gareth. Rich people buying silence with money, that's unacceptable, isn't it?
It certainly seems unacceptable, and it doesn't feel right, but we don't know whether these people are guilty yet. And it's not the way which we resolve disputes in this country. It's by naming and shaming people, or it shouldn't be the way in which we do it. The answer is there needs to be a test of evidence, and these people will be cross-examined, and we'd find out the right answer. Now, those women or men, and we don't know who they are, decided to settle their claims, often for very good reasons. Totally understand why they wanted to do that, and they've probably been given a substantial sum of money for that. If you start unpicking the ability to settle discrimination claims, whether harassment or otherwise, confidentially, there will simply be fewer claims settled, fewer claims brought. The average person who actually wants to bring a harassment claim will find that a less attractive, not more attractive.
But are you saying that if we didn't have these non-disclosure agreements, if we didn't have injunctions, what we would get would be trial by media?
Well, that seems to be what's being suggested right now. Yes, I agree.
Suzanne?
I think the politicians are missing the point. The key issue for me is access to justice. So my concern is that adverse publicity impacts both sides. And we have to look more carefully at what is causing the vast majority of people to sign NDAs. An extremely costly litigation process, adverse publicity that stops people getting fresh employment. And instead of thinking about the odd, very occasional unethical NDA, we need to be looking at a court system that prevents ordinary people getting access to justice. That's why they sign NDAs, because court cases cost too much, it's unpredictable, and the process is convoluted.
But in this particular case of the name that's not been disclosed in the Telegraph, would you like to see that name in the headlines on the paper?
If they're found guilty at the end of the day, then yes, but that's never going to happen in this case because the case was settled.
But a trial first and then publicity is what you're saying.
You need to not publicise until they're found guilty. But in any event, Jess Phillips again is missing a point here. The complainants can go to the police. The NDA does not stop them doing it. Criminal activity cannot be prevented by an NDA, and you can't not disclose it as a consequence.
So what you're saying then is actually keep the system in place as it is, because if you're going to have if you have to have a trial first, there's no way you can reveal any of these names in public.
I think part of the problem for the Telegraph was the complainants did not support the naming of this individual. Perhaps the decision of the Telegraph might have been different had that been the case.
Isn't the bigger question here, Gareth, is where do we get the right balance between accountability and a witch hunt? In America, they have the First Amendment. So, as I said earlier, if Harvey Weinstein had happened in this country, we might never have known about it. But many people are glad that we did.
Well, clearly, there is an issue about these people being able to hush it up. And there are undoubtedly, I've dealt with cases where I felt that rich people have acted with impunity, knowing that they can buy off potential claimants. That is clearly a fault of the system. However, the question is, how can it sensibly be rectified? What is the alternative? The alternative seemingly to be proposed is that when someone signs a non-disclosure agreement, it's not valid. Now, if people cannot sign confidentiality agreements in discrimination claims, as I said before, there will be fewer settlements. Fewer settlements will mean fewer cases brought, means fewer people getting fewer remedies. And I'm afraid sometimes hard cases make bad law, and this would be a hard case making bad law.
Do you agree with that, Suzanne?
To an extent, but I go back to my point. Overhaul the system. The politicians are ignoring the key point. overhaul the tribunal and court systems, make it easier for people to bring claims, make it easier for them to access justice, make it easier for them to have private hearings. We're forgetting the fact that employees are Googled every time they apply for employment. So it isn't just perpetrators or alleged perpetrators that are impacted by media interests.
Just remind us in practical terms what the hurdles are right now. I mean, how would that work? If you wanted to go to, to the police or go to tribunal, what would the hurdles be that would prevent you from doing so?
No NDA can stop you going to the police. I want to make that absolutely clear. Or to a regulator. No NDA can do that. An NDA should make it clear that they can't prevent you doing that. But the real hurdle with litigation is unpredictability, fear of publicity, and cost. So look at the system. Find an easier way for people to have shorter hearings without prejudice, in private, to resolve their disputes. Bring in arbitration. Stop these lengthy 2-3 week trials that, frankly, only really help the lawyers.
Yeah, and are often very damaging for the claimants, aren't they? Just in terms of
extremely damaging.
Gareth?
I mean, I would add to that, it's the sheer length of time it takes to get a case onto trial. I mean, a year and a half is probably fairly normal at the moment to get an employment tribunal case onto trial, and that is just a year and a half of people living in suspense, worrying about it. But can I just add to a point?
Briefly, yeah.
Yeah, which I agree with Suzanne about, which is the system's worse than ever, actually, in terms of publicising if someone has brought a claim. That is now, only as a result of a recent reform, available on a Google searchable database. And anyone who brings a claim, particularly if they've got an unusual name, it will be the first result that comes up on Google.
And you have to ask the question with open justice. Do you need to name people? Are their names relevant to the issues in the case or not?
OK, what's relevant at the moment is that we've run out of time. Thank you very much indeed, Suzanne Mackay, Gareth Brahams. Thank you very much indeed.
The retail billionaire Sir Philip Green has been named in Parliament as the businessman behind an injunction against the Daily Telegraph, stopping it from publishing allegations about him. The owner of Topshop was named by the former Cabinet Minister, Lord Hayne. He said he had been contacted by someone intimately involved in the case and felt it was his duty to use parliamentary privilege to reveal Mr. Green's identity, defying the injunction from the Court of Appeal. Our business editor Simon Jack reports.
What are you gonna do?
Retail tycoon, fashion billionaire, friend to the rich and famous. Sir Philip Green was this afternoon named as the mystery businessman who took out a gagging order to prevent the media reporting claims he bullied and sexually harassed employees. An ex-minister used powers reserved for parliamentarians to say what they like without fear of being sued.
I feel it's my duty under parliamentary privilege to name Philip Green as the individual in question, given that the media have been subject to an injunction preventing publication of the full details of a story which is clearly in the public interest.
The newspaper that had been gagged by the court said it was right he had been identified.
In the post-Me Too era, it's right to report that, first of all, a very senior businessman has used power, money and influence to try and silence employees who have claims of wrongdoing against them. And also because we think our readership would expect us, particularly having been the newspaper who broke the expenses scandal, to hold senior high-profile figures to account.
His reputation as a deal-maker saw politicians court him. In 2010, David Cameron asked him to advise government departments on how to drive a harder bargain. But his crown slipped when BHS went bust shortly after he sold it for £1 to a former bankrupt. It cost 10,000 workers their jobs and saw 20,000 facing pension shortfalls. Facing a committee of MPs with tough questions,
Sir Philip, welcome.
He gave as good as he got.
So do you mind not looking at me like that all the time? It's really disturbing. Put your glasses back on, you look better with your glasses on. I just think that's an unnecessary statement. I think you should withdraw it. I think it's very rude.
Sir Philip promised to sort the BHS pension issue, and he did, with £363 million of his own money. But using his fortune to keep his name out of the headlines is proving more difficult. Simon Jack, BBC News.
Our legal correspondent Clive Coleman is with me. Now, how much of a surprise is it that this injunction has been broken in this way?
It's a pretty big surprise, Sophie. If judges who've heard all of the evidence, listened to legal argument, written long and detailed judgments, can be second-guessed by parliamentarians who haven't, then the courts and the judiciary are going to be damaged, and eventually the parliamentary authorities are going to have to take some sort of action. Now, a similar case arose some 7 years ago when John Hemming, the Lib Dem MP, named the footballer Ryan Giggs, effectively breaching an injunction which was protecting information about an alleged affair. Now, that led to real concern that the use of parliamentary privilege was being used to pierce court orders and injunctions. Efforts were made by the parliamentary authorities and the judiciary to ensure that these two very powerful arms of the Constitution respected one another's roles. Now, it's a really difficult balance to strike because the right of parliamentarians to speak freely in Parliament is enshrined in the 1689 Bill of Rights. It's really important, but so is the rule of law. Now, no one doubts that the abuse of non-disclosure agreements by rich and powerful people to gag victims of abuse is hugely important. But before you have a full trial, who's better placed to judge what's in the public interest? Is it parliamentarians or judges?
Clive Conlon, thank you.
Now, the top shop billionaire Sir Philip Green is tonight facing claims about his conduct. Labour's Lord Hayne used parliamentary privilege to name Sir Philip as the powerful businessman alleged to have used non-disclosure agreements and payouts to conceal Philip as the powerful businessman alleged to have used those payouts to conceal his identity. He has denied all these allegations, of course, and has categorically and wholly denied them. Here, we hope, is a report. Okay, we're now moving. We're going to try and bring you that report a little bit later, but we're now going to come to another. Okay, all right. Well, earlier I spoke to, apologies for this, a few technical gremlins in the system, but earlier I spoke to Zilga Perkins, who of course was instrumental in the naming of Harvey Weinstein almost exactly a year ago.
Well, I think it shows exactly the problem with these NDAs and the intimidation that they've created, that people genuinely are so enthralled to this contract law, which is currently being used completely unethically. And the fact that the only way to do this was for somebody with some moral fortitude to stand up in the House of Lords shows the magnitude of the problem.
Because if the Harvey Weinstein scandal had happened in this country, we might never have heard his name.
No, you might never have heard his name. Although I still think I would have been very keen to come forward and break the non-disclosure agreement, mostly because I think what I've been trying to highlight with coming forward is that it's actually the legal environment and our system that is the problem. And, you know, until legislation and regulation is changed around these agreements, you know, the behaviour of rich and powerful men and women is not going to change.
I mean, one of the reasons behind some non-disclosure agreements is to make it very painful, to create jeopardy for people who try and break that. You broke it. You went through that process. How painful was it?
It wasn't as painful as it would have been if the Weinstein allegations hadn't come out so strongly. I had to take quite a calculated judgment risk on that, and I felt that surely public opinion would be in favour of the fact that a man who is being accused of being a serial rapist or alleged rapist was more in public interest than holding to a contract.
It's been a year now since the Harvey Weinstein scandal broke. How much has changed in that year?
I think a lot has changed in people's attitude. I don't know that very many practical changes have taken place yet, but that doesn't, I mean, I'm filled with optimism still, and particularly by today, because I believe that the environment is really changing and that people are understanding that this isn't just a lot of sort of hysterical women. This is much more important. It's about power abuse and it's about equality. And the equality is not just gender. The NDAs are being used throughout the country, throughout the world, not just for sexual harassment, but again, for discrimination, you know, for maternity issues, for race issues, and even for, you know, environmental disasters that happen. And the ethics behind how they're created, how lawyers behave, what they're used for, has to be completely changed.
Zelda Perkins, thank you very much indeed.
Not at all.
Well, as I tried to mention earlier, Labour's Lord Hayne used parliamentary privilege to name Sir Philip Green as the powerful businessman alleged to have used non-disclosure agreements and payouts to conceal allegations about sexual harassment, racist abuse and bullying. That's following a Telegraph investigation. Now, in a statement tonight, he said that he categorically and wholly denies these allegations. Here, finally, is Jessica Savage with the day's events.
I feel it's my duty under parliamentary privilege to name Philip Green as the individual in question, given that the media have been subject to an injunction preventing publication of the full details of a story which is clearly in the public interest.
Using an ancient parliamentary privilege, Lord Hayne this afternoon named the very modern man he believes is at the centre of the Telegraph newspaper's court injunction.
A powerful businessman using non-disclosure agreements and substantial payments to conceal the truth about serious and repeated sexual harassment, racist abuse and bullying, which is compulsively continuing.
Lord Hayne's comments are yet to be proven, but this evening the leader of the Liberal Democrats, Sir Vince Cable, has said that if the allegations are correct, Sir Philip Green should certainly be stripped of his knighthood. The billionaire businessman sits at the helm of a retail empire that includes Topshop, Burton, Miss Selfridge and Dorothy Perkins, to name just a few. Philip Green made his fortune in the 2000s, and those who detailed his success say his appetite for business and for money was insatiable.
He owned a quarter of the high street. He was constantly breathing down the neck of big retailers, not just Marks and Spencer's. You know, he was always on the lookout for buy more stores, build his empire. And the general view on the high street is that big executives on the high street, managers of stores and so on, ran in fear of Philip Green.
His bullish reputation was further cemented when he appeared before the Parliamentary Select Committee in 2016 to answer questions about the collapse of the department chain store BHS and the gaping hole in its pension pot.
I just think that's an unnecessary statement. I think you should withdraw it. I think it's very rude. Which bit of don't remember is difficult for you to listen to? Could you, sir, do you mind not looking at me like that all the time? It's really disturbing. Sorry? No, you just want to stare at me. It's just uncomfortable, that's all.
Although he did eventually cough up millions for the BHS pension pot, Sir Philip Green's reputation was left in tatters. And today, the man not known to shy away from an argument released this statement. "I'm not commenting on anything that has happened in court or was said in Parliament today. To the extent that it is suggested that I have been guilty of unlawful sexual or racist behaviour, I categorically and wholly deny these allegations." He added that his Arcadia group takes accusations and grievances from employees very seriously, and that when one is raised, it is thoroughly investigated. In using parliamentary privilege today, Lord Hayne alleged Sir Philip Green is the man at the centre of this week's highly publicised Telegraph newspaper court injunction. The newspaper was and still is blocked from naming an individual at the centre of an investigation into allegations of sexual harassment and racial abuse, and the use of non-disclosure agreements. While the spotlight now appears to have been shone on Sir Philip Green, the newspaper and politicians say there's a wider debate around these non-disclosure agreements being misused.
Our argument has always been that this injunction and indeed the non-disclosure agreements that were signed by employees claiming wrongdoing against a senior businessman who is well known to the public were wrong and misplaced.
And I think that parliamentary privilege being the only answer in this case, because of injunctions against that were intended to be about people's private lives being misused and bent to the will of rich people, I think it was the only way, and I think Peter Hayne today was incredibly brave and he did the right thing, because we cannot let people believe that they are above the law, just as I don't think that I am above the law.
Tonight, Sir Philip Green, a titan of the high street, is a man determined to defend his reputation.
He'd spent $500,000 trying to keep his name out of a newspaper, but billionaire former BHS boss Sir Philip Green couldn't stop it being revealed in Parliament. He was named under free speech rules by a Labour Lord as the businessman facing allegations of sexual harassment and racial abuse of staff. Once his name was out there, Sir Philip issued a denial, saying he was not guilty of unlawful sexual or racist behaviour. The Daily Telegraph had been investigating the claims for 8 months. Sir Philip avoided his name being released by using controversial non-disclosure agreements with his alleged victims.
Until today, a court injunction prevented the Daily Telegraph identifying the leading businessman facing unsavoury allegations. That changed this afternoon as retail tycoon Sir Philip Green was named in the House of Lords. Former Cabinet Minister Lord Hayne using parliamentary privilege to do what he called his public duty.
A powerful businessman using non-disclosure agreements and substantial payments to conceal the truth about serious and repeated sexual harassment, racist abuse and bullying, which is compulsively continuing. I feel it's my duty under parliamentary privilege to name Philip Green as the individual in question, given that the media have been subject to an injunction preventing publication of the full details of a story which is clearly in the public interest.
Sir Philip hasn't been seen in public today, but issued a statement this evening categorically denying any allegations of unlawful sexual or racist behaviour. As the chairman of Arcadia Group, Sir Philip Green controlled brands like Topshop, Miss Selfridge and Dorothy Perkins. But he has not been without controversy. His sale of BHS for £1 before its collapse within a year, leaving a £500 million hole in its pension fund, caused MPs to brand him the unacceptable face of capitalism. In a memorable encounter, he rejected much of their criticism.
Which bit of "don't remember" is difficult for you to listen to? Do you mind not looking at me like that all the time? It's really disturbing.
The Court of Appeal had banned publication of allegations from 5 former employees because the 5 had signed non-disclosure agreements. An element of workplace law politicians from all parties agree is in need of urgent reform.
Well, I think in this particular case, Parliament has proved its worth by showing that the non-disclosure agreement is valueless. And I think that's a very good expression of how democracy can be used. The government obviously has got to now act on legal advice as to how the law can be changed and then to change it.
Lord Hayne is certainly not the first and won't be the last parliamentarian to use parliamentary privilege, perhaps to overturn injunctions. It's happened before. I think the fact that he's done that raises bigger questions about whether the injunction was appropriate in the first place.
The Telegraph will continue to press for the injunction to be lifted now that Lord Hayne has ensured Sir Philip Green's name is firmly in the public domain. Paul Davis, News at 10.
Martha Fairley is outside the headquarters of Sir Philip Green's Arcadia Group tonight. Martha, what more has Sir Philip had to say tonight?
Well, as you've already mentioned, Sir Philip Green has wholly denied these allegations. And in the statement that was released earlier this evening, he said, "Arcadia and I take accusations and grievances from employees very seriously. And in the event that one is raised, it is thoroughly investigated. Arcadia employs more than 20,000 people and, in common with many large businesses, sometimes receives formal complaints from employees. In some cases, these are settled with the agreement of all parties and their legal advisors. These settlements are confidential," he says, "so I cannot further comment on them." Well, we haven't seen Sir Philip Green today at the Arcadia headquarters here in central London, from where he runs the retail empire. But there are signs that today's events may prove damaging for Topshop, one of the best known of Arcadia's brands, because tonight there are calls from female customers of Topshop to boycott the store, and those calls are spreading across social media.
All right, Martha, thank you very much indeed. And the internet company Google has tonight admitted sacking 48 members of staff over claims of sexual harassment. It said they included 13 senior managers. The company added it was taking an increasingly hard line against inappropriate behaviour.
It's not the first time that an attempt to control the flow of revelation or allegation about the
behaviour of a public figure has collapsed spectacularly. The Telegraph says Sir Philip Green had spent almost £500,000 on the legal effort to close the story about him down. Allegations of bullying, sexual harassment and racism against staff. He denies any unlawful sexual or racist behaviour and had secured an interim injunction against the Telegraph's reporting. But his name has been thrown into the public domain by Peter Hain, Lord Hain, in the House of Lords this afternoon. Now, there are three pieces to the story today. There is the issue of parliamentary privilege being used by Lord Hain to undermine a court injunction. Then there is also the issue of non-disclosure agreements in alleged sexual harassment cases. And then thirdly, there is, of course, Sir Philip Green himself. Guilty or innocent of the disreputable conduct of which he's accused, he has lost control of what is said about him. Let's start there. Here's our business editor, Helen Thomas.
He was the UK's King of the High Street. Known in the noughties for his extravagant taste in multi-million-pound birthday parties, his photo ops with supermodels, and for his business empire, an array of well-loved retail names that included BHS, Topshop, Evans, Wallace and Miss Selfridge. He was, in his own words, an uneducated, unqualified guy who left school at 16 and got his start in London's rag trade in the 1970s.
I've been intimately involved in virtually every aspect of this business over 40 years, 45 years. Taught myself.
But Sir Philip Green's fall from grace is proving as dramatic as his business ascent.
I feel it's my duty under parliamentary privilege to name Philip Green.
The retail billionaire was today named in Parliament as the businessman at the centre of allegations of bullying, sexual harassment and racial abuse reported by the Daily Telegraph.
Is that a question to me?
Yes, it is. Sorry, beg your pardon. Yes, it is.
He had shot to national prominence at the end of the 1990s, with the first of two unsuccessful attempts to buy Marks and Spencer.
Great value, good quality.
Then came the £200 million purchase of BHS in 2000, and in 2002, the deal to buy Arcadia, the group that houses many of his best-known brands. Times were good. A £1.2 billion dividend in 2005 went to Arcadia's ultimate owner, his wife Tina, based in Monaco. That prompted an outcry over the tax saved, but a knighthood followed in 2006. In 2015, Sir Philip was still rubbing shoulders with the great and the good.
Sir Philip Green is going to be, it's going to be ka-ching scenario.
But the cracks were showing. Early that year, he sold BHS for £1. Its collapse a year later left 11,000 staff out of work and payments to 20,000 current and future pensioners under threat. In parliamentary hearings, MPs got a taste of Sir Philip's famously combative style.
Do you mind not looking at me like that all the time? It's really disturbing.
The businessman last year agreed to put £363 million into the BHS pension scheme. Sir Philip has faced allegations of bullying before. The book Damaged Goods, published this summer, claimed he had reduced staff to tears with expletive-strewn rants. One employee, the book said, alleged he was racially abused. The businessman today said he was not commenting on what was said in Parliament. But, he said, to the extent that it is suggested that I have been guilty of unlawful sexual or racist behaviour, I categorically and wholly deny these allegations. Sir Philip said this year that he had behaved like a gentleman with regards to the BHS pension scheme. He now finds himself battling a new challenge to his much prized reputation.
Helen Thomas. Well, the man who stood up in the House of Lords and named Sir Philip was Peter Hain, using parliamentary privilege. That's a legal immunity that protects parliamentarians against legal action in respect of what they say inside Parliament. For example, it stops parliamentarians being sued for libel. But this case is more complicated than that, because here the Master of the Rolls had ordered an interim injunction to block the naming of Sir Philip Green. I sat down with Lord Hain this evening and asked why he had used parliamentary privilege.
Parliamentary privilege is something to be used with integrity, very sparingly and very responsibly, because Parliament is sovereign and parliamentarians, MPs and peers are entrusted to use it in that fashion.
A lot of people will say this is a case where judges had made one decision, a politician has now come up and made a different decision and undermined the decision that the judges had made. And this is an awkward constitutional clash. This isn't like a libel case where you've just said, I want to denounce someone for bad behaviour. This is a case where the judges had applied an injunction, an interim injunction.
Well, the judiciary, in this case judges, have their role to play. It's a very important independent role. The rule of law depends upon them exercising it carefully and responsibly in accordance with legal precedent. But parliamentarians also have their role to play. It's for members of the public and others to judge whether what I've done in this case is right or wrong. I believe it was the right thing to do. I considered it extremely seriously before I said it, as anybody who's using parliamentary privilege always does.
I mean, does it make a difference that it was an interim injunction, that the Master of the Rolls had said this has to go to a full trial? He urged it to go to trial as expeditiously as possible so that the issues could be resolved. And in a way, you've jumped the gun. You haven't waited for the full process to be gone through.
I'm not disputing judges' responsibilities or timing or anything like that. That's a matter for the judiciary. I'm discharging my function as a parliamentarian, and what concerned me about this case was wealth and power that comes with it, and abuse, and that was what led me to act in the way that I did.
There's one other argument people have used against your action today, which is that there were two of the women who had signed NDAs had supported the kind of the privacy about all of this, and they had supported the injunction. They're on the other side, if you like. They're not, they're not powerful. They're not people who have money and legal bills and all of that. Now, does that make a difference as to whether this was the right moment to come?
Well, again, others will make a judgment about this. I explained exactly the circumstances to Parliament today in which I was contacted by somebody intimately involved in the whole thing.
And you can't tell us more about that?
That would be to betray that person who's extremely vulnerable, and I'm not going to do that.
Can I ask when you found out?
You can ask all you like, Evan, but I said what I said openly, and I stand by it. And sometimes you have to take tough decisions. It's for others to judge whether I've been right or wrong. But there's no point in being in Westminster, which is the sovereign centre of the British Constitution, has sovereignty, and with it the parliamentary privilege that is a privilege. There's no point in being there if you never discharge that, if you never deploy the precious rights of parliamentary privilege to be used, as I've said, extremely carefully, with integrity and very responsibly, never just loosely.
Can I ask what reaction you've had? It's about 3 hours, I think, since you stood up in the House of Lords.
Well, there's been some criticism on social media, but I've had overwhelming support, particularly from women.
Lord Hayne, thank you very much.
Thank you.
Well, I'm joined by Camilla Tominey, Associate Editor at the Daily Telegraph, and Sarah Chilton, an employment lawyer who's a partner at C.M. Murray. Evening to you both. Camilla, did you know this was going to happen? Were you as surprised as the rest of us when Lord Hayne stood up?
We had an inkling that perhaps a parliamentarian might want to step forward. We didn't expect it to be a senior lord, obviously with quite an illustrious history of fighting injustices. Everyone's probably familiar with Lord Hayne's previous work on the anti-apartheid movement, and indeed as him being a former Secretary of State and late Leader of the Commons. So
you hadn't coaxed him on it or coaxed him on it really there?
No, effort, no. That would be breaking an injunction, wouldn't it?
And I mean, sort of ironically, you're still subject to the injunction, in fact, aren't you?
Well, this is the kind of farcical nature of the law as it stands at the moment. We're subject to the injunction, so Lord Hayne has named Philip Green. We can't comment on the veracity of that. We have to continue publishing within the terms of the injunction until it's overturned.
Right. Right. Do you know, by the way, when that's going to be? Because there is going to be a trial, isn't there? Full trial. That's the plan.
Well, we're considering all of our legal options at the moment and taking advice from our own lawyers. But obviously, we're still going to be championing freedom of the press. That's what we exist to do. The Telegraph has had an illustrious history of holding power to account. You will be familiar with the expenses scandal in our coverage. That's what we intend to do on behalf of readers.
Sarah, can we talk about NDAs? Because underpinning the injunction was this potential or apparent breach of confidentiality, which Sir Philip Green was entitled to expect because he had NDAs, and not just because he had NDAs. They do obstruct the flow of information, and often that is in the public interest, isn't it? The information is in the public interest.
That's right. They can obstruct the flow of information, but I think what I suppose is worth bearing in mind is that they are incredibly common in these type of agreements, in these settlement agreements, which often happen at the end of an employment relationship. And so there are certain limitations on them in the law. So, for example, they cannot prevent someone making certain types of disclosures. They cannot prevent someone reporting a crime. So there already are these limitations on them.
So even if someone signs one that tries to shut them up reporting a crime, they are allowed, without breaking the NDA, to go and report the crime.
That NDA would be invalid. I think what's important, though, to bear in mind is that a lot of people who sign these NDAs don't know the legal limitations of the NDAs.
Well, we often think of them as, look, if it's between two consenting adults, they sign a contract, one pays one money and the other shuts up, that's them. But we don't always really know that they are consenting adults who've had the same level of advice on what they're doing.
Absolutely an issue. And I think one of the concerns that we have around NDAs is that a lot of people enter into NDAs without fully understanding what it is they're signing, the consequences of that, and not always with legal advice on that particular part of the contract.
Yeah, but a lot of victims or alleged victims do want an NDA because they don't want to tick the publicity box any more than anyone else does.
That's right, and that's why I think that they have a role, but that role has to be very carefully policed and regulated.
Yeah. Do you accept that, Camilla, that there are other people in this, involved in these NDAs who may not want them?
Yeah, and we understand that, and we equally understand that, as both of the courts pointed out, considerable sums had been exchanged. But equally, the Telegraph has always said that we weren't planning to name any of the victims in this who have come to us. I mean, we've spoken to more than 24 people over the course of 8 months, and indeed the court itself described our findings as credible.
As credible, yeah. So the alleged victims, you're not interested in naming those. Of course, Camilla, it would be highly hypocritical, wouldn't it, if a newspaper or any news organisation criticising the use of NDAs was itself to have ever used NDAs in this kind of settlement with its own staff when they leave. And I'm sure the Telegraph would never do such a thing.
Or indeed the BBC. I don't know, Evan. Do you think the BBC has used any NDAs? Because I'm not sure. Funny enough.
But I'm trying to take a neutral position on the whole issue. But do you know whether the Telegraph uses NDAs? Because it is quite common, isn't it? I mean,
do you know what? I don't. But then I joined the Telegraph on the 4th of September. So I'm quite new to the company. Quite happy to champion.
Get out of jail card.
Not a get out of jail card, just an honest answer, Evan. Do you know about the BBC?
No, I don't, but
I'm just intrigued.
No. Sarah, one of the key things here is, and a key issue in the whole case, is it's not the Telegraph's job to police a private NDA between two people. If one of them, and this is not in this case or any case, if someone breaks their NDA, it's not the court's job to uphold the NDA. It's a civil matter, isn't it? The court can't stop someone. The Telegraph have never signed an NDA with Sir Philip Green or anyone else.
Well, the interesting thing in this case is that there is a suggestion in this particular case that the information which the Telegraph obtained was obtained in breach of an NDA. So I think that's what would engage that debate.
But that's not the Telegraph's problem. I mean, that could be the people who signed the NDA's problem, and then they go to court and fight it out among themselves if they think someone has...
And that might become the people who signed the NDA's problem, although I think from a PR perspective, I'm not sure with how much veracity an employer in this situation would like to pursue those individuals. I'm not sure that would play out very well for an employer's perspective, but, you know, there is that's a whole different potential legal action.
Camilla, does the naming in the Lords today of Sir Philip Green, does that induce you to go back to the courts and say you want the courts to reconsider the injunction, or do you wait for the trial now?
Well, I think that's down to the lawyers, and the latest position is we are literally, at the moment, considering our options because of what's happened in light of this afternoon. you know, we want to publish, and we want to publish in full, and we think that it's in the public interest to do so, and we'll continue with that battle. That's my understanding as it stands at the moment, and I think we owe, like Lord Hayne today owes a duty of care to the public, we think we owe one too.
Camilla, Sarah, thank you both very much for coming. Thanks.